Good evening. This is John Milburn for Laws 12066. This is Land Law, Week 11. 1 week to go after this, and both weeks, tonight and next week, cover substantive issues. This week, we're dealing with easements. Next week, we deal with mortgages. And in your examination, you will have a question on either easements or mortgages, or maybe both. So we've got a lot to cover tonight. Again, most of it is statute-based. So if you're following along either live or watching as a recorded session, please have access to your legislation, and I'd like you to read that, consider it as we proceed. Easements tonight. So obviously we're talking about the characteristics of an easement, the creation, the extinguishment and modification of easements. And most of that is found in the Land Title Act 1994 in Queensland. So have that piece of legislation ready to go. So what is an easement? Well, it gives someone the right to use land for a specific purpose. It's named, it's got to have a particular purpose, even though they're not the landowner. And in addition to easements that are granted to another person, usually a neighbour, we do have statutory easements for things like services, electricity, or water, stormwater, things of that nature. So given that an easement creates, for the benefit of someone else, usually a neighbour, an interest over land, which is then subject to the easement, we talk about the dominant land, or back in the old days, we used to call it the dominant tenement. So the dominant land is the land that is benefited by an easement, taken over the servient land, which is the land burdened by the easement. So dominant and servient are the terms that we use. We also briefly consider profits a prondra. They're not technically easements, but they confer a right on someone to enter onto somebody else's land for the purposes of taking resources. The case that you'll come across most often at the early stage of describing an easement is re Ellenborough Park. It's an English decision, a couple of English decisions tonight. This is 1956, Chancery 131-4. And the requirements were identified for the creation of an easement. I don't recommend you go and read this case. Others I will ask you to read and consider. Not this one. But it's relevant because it's Chancery 131, and it's relevant because we have 4 requirements identified for the creation of an easement. Again, we need a dominant and a servient tenement. That is in theory. I'll mention some exceptions later. The easement must accommodate the dominant tenement. It's got to be for the benefit of the dominant tenement. The owners of the dominant and servient tenements, or if you like, land, must not be held and occupied by the same person. That's number 3. And number 4, the right must be capable of forming the subject matter of a grant of an easement. I mentioned before that easements are for particular purposes or particular purpose. So, and that needs to be specified, and that must be capable of being the subject of the grant. So they're the 4 requirements identified at common law, but the common law position is altered by statute and by commercial practice. Shortly, we'll look at Section 87 of the Land Title Act in relation to existing easements. And also we'll consider briefly easements in gross. Easement in gross, which is often and typically created as a result of a developer creating a subdivision, a new subdivision. All right, so in fact, let's have a look at Section 87 now of the Land Title Act, because whilst I've mentioned the common law position, which says that the dominant and servient tenement holders must be different people, Section 87 provides an exception. And it says, if the same person becomes the registered owner of the lot benefited and the lot burdened by the easement is extinguished only if the registered owner asks the registrar to extinguish it, or the registrar creates a single indefeasible title for the two lots. In other words, if there's an amalgamation of the titles. So you can see then that where we have an existing easement, maybe neighbouring properties, one property owner buys out the neighbour, then we have the same owner owning both properties. That does not necessarily immediately extinguish the easement from the title. It remains there, which therefore means it's an exception to the common law principle in re Ellenborough. I hope that makes sense. Also, while we're at it, look at section 88 of the Land Title Act, and it says an easement is not extinguished merely because the owner of the lot benefited by the easement acquires an interest or greater interest in the lot burdened by the easement. Similar concept. Now, it may be apparent. Yes, Monique?
Monique, just to clarify, does section 88 really just reinforce section 87 in that the owner needs to take positive steps to have the easement extinguished? It doesn't happen automatically?
That's correct.
Okay,
yes.
Thanks.
That's it. So they're basically adopting the same approach, the same principle. So thank you for that question. All right. So it may be apparent, but easements run with the land. So all future owners of the servient tenement, that which is burdened by the easement, are bound by the easement unless it's surrendered or it's extinguished. And we'll talk about how that can happen. It's a few ways it can happen. So one is, of course, if the same person owns both, can apply to the registrar to have it removed, extinguished. Now, the easement must benefit the dominant tenement. In other words, the dominant tenement must be made better or because of the existence of the easement. There must be a connection between the easement and the land itself. So what we don't see is, an easement in favour of someone who has no association with the property, for example. That can be a profit or prondra, but not an easement, unless it's a statutory easement. Now, I mentioned briefly easements in gross, and an easement in gross is usually to serve the purposes of a local government or some sort of government instrumentality during the process of creating a subdivision, where the development might be approved, provided there is built into the subdivision a right of way to allow members of the public to access a beach or a park, or a statutory type easement to allow for services to be provided, or an easement to allow people to have proper access, a right of way to the blocks which are at the back of the subdivision. Things like that, the things that might occur during the process of approval. All right, now in the study guide you would have seen the prescribed reading from your primary text, chapter 10, and from your secondary text, LexisNexis Q&A, chapter 9, but restrict your discussion to easements only in that regard. Now, I mentioned the Land Title Act. Before we get into Division 4, which deals specifically with easements, just a note about the order of registration of instruments. You're probably well aware of this, section 177, which says that, in essence, instruments are registered in the order in which they're lodged. But the reason I'm highlighting it is that in that section, there is an example, and the example includes a reference to an easement. So there's relevance for tonight. And the exception is that a later document might be registered first if it has no effect in reality on the first document. So, for example, somebody might lodge a document, then it's requisitioned, and there's a period of time while that requisition is resolved. Somebody else lodges a document. Normally, you'll have to wait, but if it has no effect on the first document, then it can proceed through. So the example is in section 177. An instrument of easement over a lot is lodged for registration. Later, an instrument releasing a mortgage of the other lot is lodged for registration, the servient tenement, because the release of the mortgage has no bearing on the easement, the titles office will allow that second document to be registered. Anyway, just really an aside. Let's have a look at Division 4 of the Land Title Act. It's in Part 6. Part 6 is dealings directly affecting lots, and Division 4 relates specifically to easements. That's sections 81A through to 92 inclusive. Have a look at the headings for each one of those sections briefly now to get a feel for it. And you'll see that it relates to the creation, registration, limitation process, particulars that might be registered, the issue of easements benefiting and burdening the same owner's lots, which is 86, then 87, 88, which we've talked about. 89, easements for public utility providers, which is statutory easements. And then at the end, 90, surrendering, easements coming to an end over registered leases in certain circumstances, and then amendment. And finally, section 92, which talks about the application of the Property Law Act, section 181. You'll note that Division 4AA deals with high density development easements. And I'm not really going to deal with that in this unit. So as far as the examination preparation is concerned, you really need to focus your attention primarily, and certainly initially, on Division 4, Part 6 of the Property Law Act. Now, an easement, unless it's otherwise stated, is granted in perpetuity. And wasn't it just last week or the week before we talked about the rule against perpetuities, and now I'm saying that an easement is granted in perpetuity. Anyway, it's there unless it's removed or it comes to an end in some way. And it is possible to restrict the time that an easement is of effect. It might be granted for life only, or a term of years, or upon the happening of a certain event. Or it might be that whilst someone is a lessee, they have the benefit of an easement. When the lease is expired, then so too the easement comes to an end. So there's different ways to structure it. So bear that in mind, because people tend to think of easements as being permanent in perpetuity, and most of them are, but they don't have to be. And also when we think about easements, we probably think about rights of way or drainage easements, the ability to travel through, but they can be all sorts of things. So easements, for example, might be a right of way. And do you know what I mean by a right of way? The right to drive your car down there. If you read old easements, they're very funny in the way they're described, because they talk about horses and carriages and all that sort of stuff. But not surprisingly, I guess. But easements might also be support of building easements, easements that relate to party walls or drainage or services, electricity, stormwater, things like that. Now, easements, you would think, are generally created by consent between the owner of the dominant and the servient tenements, but they don't have to be. A court can order an easement come into existence, or an easement might come into existence as a result of a compulsory acquisition. So what we're going to do now, and again, if you have any questions, comments, please unmute the microphone, use the chat facility. That would be good. But let's have a look at the Land Title Act. We're going to work our way through Division 4, and I'll take a few diversions as we go. So let's start with Section 82, the creation of an easement by registration. And an easement over a lot may be created by registering an easement, an instrument of easement. An easement may be created over a registered lease, may be created the same way. And subsection 3 says the instrument must state the nature of the easement, and it must state the land benefiting or benefited or burdened by the easement. So that's all in Section 82. Now, in practice, an easement will usually come into existence as a result of a survey plan being drawn and registered in a subdivision context. But it can go beyond that. Now, bear in mind that Section 82 refers to legal interests, legal easements, because we've got that word registration. Registration of an instrument of easement tells you it's a legal instrument. It's a legal easement. And almost all of the easements that we'll need to discuss are legal, but it is possible to create an equitable easement. For example, if the grantor is a beneficiary of land held under trust, then that person only holds an equitable interest. Therefore, if they grant an easement, can only grant an equitable easement. Or if someone who is acquiring the property under a contract of sale grants an easement, it can only grant an equitable easement because that person only has an interest in equity. I wouldn't worry about that too much, but you may come across some commentary that talks about equitable easements. In practice, they're not really that important or relevant. Okay, now just as a digression, the first digression, can anyone tell me what is the process of actually registering an easement? If you want to have something on the title, what do you do? Does anyone know? Sort of a little wake-up question. Make sure you're still there. How do you go about registering an easement?
You have to complete a Form 9 easement document that will be lodged with the Titles Office. Okay,
great. And where would you find this Form 9 document, Sarah? And you're absolutely right.
On the Land Titles website.
Land Title
website?
The
Department of Natural Resources, Mines and Energy website.
Okay. And what's the handbook? What's the is that the Land Title
Practice Manual?
Land Title Practice Manual. So from a practical perspective, that's always a great place to look. So I've just got one here that I want to share on the screen, if I can find it. I think this is it. So hopefully, when I share the screen, you're looking at a Form 9 easement. And I'll just enlarge the panel a bit there. So you can see that it is the Form 9, as Sarah mentioned. You'll see the name of the grantor or grantors. It's an easement A over registered plan. I think they're more likely to be survey plan or SP now. County of Stanley, Parish of Nunda. I'm not sure we have those anymore from a practical perspective. I think they've gone, but this is an older form that we're looking at. But the idea is there. You'll see there's consideration, $1, pretty typical for an easement, and the purpose, a right of way, so to come and go, and then signed and dated. This is old. This is from 2007. So the form is the same number, but some of the detail has changed. I'll stop the share there. Okay, so that's from a practical perspective, how you go about granting or recording the instrument of easement. Now let's again go back to, before I go back to the Land Title Act, I'll just mention there's another way of creating an easement, and that is through Acquisition of Land Act, and the third way is through Statutory Rights of User. So I've just reproduced some of the sections that are relevant. I'll share the screen again, and hopefully you can now see the Acquisition of Land Act 1967. Section 6 deals with easements, and the Property Law Act, the PLA, the Statutory Right of User, where it is reasonably necessary in the interest of effective use in a reasonable manner that the owner have a statutory right of user, the court can make an order to that effect. Now I'm paraphrasing there. But keep in mind, Section 6 of the Acquisition of Land Act, to do with the process of constructing authority, instead of taking the land by way of compulsory acquisition, can instead take an easement by way of compulsory acquisition. And statutory user, section 180 of the Property Law Act, covers those circumstances where somebody is landlocked and they need access to a road. They can apply to the Supreme Court for an order for a statutory easement under that section. All right, let's go back now to the Land Titles Act, look at section 83. Registration of an easement. We've seen what Greg says, part 13 of the Land Title Practice Manual is where you'll find some information about easements and creating easements. So thank you, Greg. Section 83 of the Land Title Act talks about registration of an easement. Section 89 talks about easements for public utility providers, and they can be for a right-of-way, so for a road, we see that often, or perhaps part of property is acquired for that purpose, or for drainage or sewerage, supply of water, electricity, telecommunications, all of those sorts of things. Public utility providers are authorised to have easements based on that section. Section 181 of the Property Law Act, bouncing around here a bit, but the Property Law Act, section 181, talks about the power to modify or extinguish easements and restrictive covenants. So again, I'll just share the screen. I've reproduced it here. And where land is subject to an easement, the court may modify or wholly or partially extinguish the easement upon being satisfied that because of a change of use of any land, the easement or the restriction ought to be deemed obsolete, or the continued existence of the easement would impede some reasonable use of the land, either does not secure the benefits of substantial value or contrary to the public interest, and money will be adequate compensation for the loss. And then it talks about persons of full capacity have agreed to extinguish or abandon the easement, and that the modification will not substantially injure someone. And the court, in coming to a determination as to whether or not to modify or extinguish an easement, is entitled to consider the town plan and any issues in relation to building. So that's a section that you'll need to consider if, in the context of your examination question, something arises in relation to the court's power to modify or extinguish easements. And presumably, of course, that would occur in circumstances where there is a failure for the parties to come to a worked agreement. In other words, where there's no consent arrangement. So section 181 of the Property Law Act. And section 92 of the Land Title Act importantly says simply this, that the Property Law Act 1974, section 181, applies to a registered easement. Okay? So that's the way it works. So you look at Land Title Act, section 92, identify that section 181 of the Property Law Act applies, then look at section 181 of the Property Law Act. Let's look at a case. This is Smythe, S-M-Y-T-H, against Brisbane City Council, 2007 QSC 30. Smythe against Brisbane City Council, 207 QSC 30. Mr. Smythe, the applicant, owned a block of land at Holland Park West near Marshall Road, near the freeway, if you know Holland Park West. And in fact, this parcel was large, 2,300 square metres. It abutted the eastern edge of the Eastern Freeway, or the Southeast Freeway, and the busway complex, so if you know where that is. Now, Mr. Smythe lived there with his wife, and he wanted to subdivide the land. It was a big block, close into the city. He wanted to create another residential block, but there were some obstacles. There was a drainage easement in favour of the council. That's why the Brisbane City Council are involved in this litigation. And the easement, in fact, covered about 60% of the land. all except the immediate house area and the driveway. The rest of the block was the easement. They couldn't come to an agreement as to what to do with this, so the matter went to court. Mr. Smythe brought an application under Section 181 of the Property Law Act. Now, under the easement, there was a deed. Nothing could be built in that area without the council's consent. And the council didn't grant consent to the subdivision and refused Mr. Smythe's application to subdivide. The major flood of 1974 was followed by extensive flood mitigation works, and that's when this easement was created. So Mr. Smythe relied on all 4 paragraphs of Section 181. I've shown you only, I went through all 4 in subsection 1 of Section 181. And in that case, Smythe against Brisbane City Council, the council looked at paragraphs B and D. And Justice Freiberg, and have a look at paragraph 28, which I think is really the key part, said, ultimately, when considering all the practicalities, considering any possible injury, injury in a more broad sense, not physical injury, but injury to the council, said, I'm satisfied that even if one takes hypothetical cumulative impacts into account, to the extent of the easement covers the land to Q100 flood, it does not secure any practical benefit of substantial utility or advantage to the council in relation to those impacts, and its modification by excluding land above that level would not substantially injure the council in relation to it. So the main part of the case related to subsections B and D of Section 181, subsection 1. All right, Section 90 of the Property Law Act talks about surrender of easements, and the registered easement may be wholly or partly surrendered by a surrender document, and that is registered document. Signed, of course, by the parties, and it can involve leases. It doesn't have to be owners of property. Just a couple of other sections from the Property Law Act that might be relevant. Section 178 of the Property Law Act says that there is no presumption of a right to access or use of light or air. But when we talk about access, temper that with the statutory right of user that I mentioned. Section 179 is the right of support to land and buildings of the Property Law Act, and for the benefits of all interests in other land which may be adversely affected, there shall be attached to any land an obligation not to do anything on or below that would withdraw support from any other land or building, structure or erection that has been placed on or below it. So of course what we have there is a situation where you can't do anything which is going to adversely affect structural walls, for example. So Section 179 of the Property Law Act. Now, remedies. So what can we do about these things? When the use or enjoyment of an easement is restricted or interfered with, the dominant tenement has some remedies. Number one is really a self-help remedy, which is abatement. If there's a problem, if somebody has blocked the right of way, abatement or self-help says, well, we'll remove it. You're allowed to do that. But there are some limitations you've got to take care. Another is if someone is not doesn't have the full benefit of their easement, then they can sue for damages for nuisance. In bringing an action, the dominant tenement must show that there was a substantial interference with the easement right and that the dominant tenement has suffered some loss from substantial interference. That's a second option. Number three is a standard declaration, a declaration of rights. So you might go to the court seeking a court declaration, simply not asking for any other relief, but simply to ask the court to make a call in relation to an issue of dispute that has arisen between the dominant tenement holder and the servient tenement holder. And then the fourth is standard damages as opposed to damages for nuisance. So just standard damages, and it can be coupled with an application for an injunction, which can be positive or negative injunction. Does that make sense? So if you're preparing for an exam question on this topic, odds are you'll need to consider the Land Title Act, the Property Law Act, the various sections that we've talked about, and you'll need to consider issues to do with remedies. Any questions so far, or all good? You're being very patient. Yes.
It might be a silly question, but is the relevant court, still determined by the value of the claim, or is there a specific court for these matters?
That's a really good question. Generally speaking, it's the Supreme Court. So if you're talking about the Property Law Act, for the definition of court, it's Supreme Court, but the District Court generally shares the jurisdiction. So it's not, for example, the Planning and Environment Court, it's not the Land Court, it's not the Magistrates Court, it's not QCAT. So in this context, and that's a really good question, thank you for raising that, think in terms of the Supreme Court or perhaps the District Court, usually the Supreme Court. And one of the ways you can be guided by this is look at the decided cases is always a good, so I think the case I've cited to you was the Supreme Court. So thank you, Monique. I'm glad you raised that. Any other questions, comments before we go on? All right. Let's talk about extinguishment or modification of easements. Now, we've already mentioned that there's some reference to that in the Land Title Act, but an easement can be extinguished, brought to an end, in 5 ways. And here they are. Number 1, by being abandoned. So it's the reverse of, adverse title. If you don't use it, then you lose it. So you can abandon it. Number 2, it can be extinguished by express release. Number 3, extinguished by alteration of the dominant tenement. So extensive as to constitute excessive use. That's a tough argument to run, but possible. Number 4, extinguishment upon unity of the dominant and servient tenement, as we discussed at the start. Number 5, through statutory extinguishment. So abandonment, express release, which is an agreement, alteration to the dominant tenement so that the use becomes excessive, extinguish upon unity of title, or statutory extinguishment. Now let's again look at a case. This is a High Court decision, and this is Treweke, WEEKE against 35 Wolseley Road Pty Ltd. 1973 128 CLR 274, and in fact it's 36 Wolseley Road. All right. The alternate citation is 1973 HCA 27. Now in Treweke, the application was brought in relation to a right of way that was created way back in 1927, and it was to do with a strip of land 3 feet wide along a side boundary of Mrs. Treweke's property, and it was used as a means of access to the beach at Double Bay, so a very expensive area, and she was the registered proprietor. Now, Mrs. Treweke's estate was diminished to the extent of the right of way, and the High Court considered the question of abandonment and basically said that there had been no abandonment of the right of way, even though from a practical perspective it had become impassable because of sheer rock faces, an impenetrable bamboo clump, and the construction of a swimming pool across the way. even with those impediments, that was still not enough to satisfy the court that it had been abandoned. So it's a pretty high test. So Trawiki is one that you might consider. Now, express released, which is the second option, obviously an agreement between the parties. The third was a change in the way in which the dominant tenement is used so that now there's an excessive use of the easement. In other words, if the dominant tenement assumes a very different character, the easement may come to an end. You don't have to read this case or review it. It's an English decision. It's Ray, R-A-Y, against Fairway Motors, Barnstaple, B-A-R-N-S-T-A-P-L-E, Limited, 1968, 20, it's an unusual citation, P and CR, P ampersand CR 261. In this case, the parties owned adjoining yards separated by a wall, and the plaintiff erected a shed at the rear of the yard and used the dividing wall as one of the walls of his shed. The defendant later excavated the property adjacent to the separating wall, and the court held, in that case the Court of Appeal in England held, that an easement is extinguished when the owner of the servient tenement proves that the mode of use is altered in such a way as to prejudice the enjoyment of the servient tenement and restrict the use to which it can be put. Kind of the reverse decision of the High Court. So I think that's in your text, pretty easily found anyway, Ray against Fairway Motors, so have a look at that. Just in general terms, just in the textbook. Unity of dominant and servient tenements, well, I guess that's pretty straightforward in that if you have that unity of the ownership, then that's sufficient to effectively extinguish the easement. But again, we've mentioned earlier that you need to apply if you want it removed. And you may not want it removed because you might want to sell one of the properties that you've acquired at a later time. Now, we're just about ready to wrap up for this evening. I'll just ask you to make sure that you're aware and consider sections 180 of the Property Law Act. We've talked about that, which is the imposition of statutory rights. Also think about section 181 of the Property Law Act. Now, a case, final case, Eucalypt Group, Eucalypt as in tree, Eucalypt Group Proprietary Limited against Robin and another, 2003 QSC 63. The Eucalypt Group sought to extinguish an easement in favour of Robin and others and failed. Now, this case involved esplanade frontage at Palm Beach on the Gold Coast. You see, most of these cases are talking about easements over very expensive parcels of land where it really matters, where a few feet matters. There was inferior alternate access available, and the court was not convinced in that case that monetary compensation would make up for the loss or disadvantage the dominant tenement's owners would suffer if they lost enjoyment of the easement. That's Eucalypt Group against Robin and another. All right, so that's it for this evening. Early night. Any questions, comments? I won't start mortgages tonight. We'll do that exclusively next week. All good? All right. Thank you for your attendance this evening. If there are any questions, please ask through UCrew. Send me an email if you want to. And all the best. We'll see you next week. Bye then.